Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 21-1035, Ammonite Oil and Gas Corporation against the Railroad Commission of Texas from McMullen County and the Fourth Court of Appeals District. Second is 21-1097, American Honda Motor Company versus Milburn from Dallas County and the Fifth Court of Appeals District. And finally, 22-242, Baker versus Bizzle from Denton County and the Second Court of Appeals District. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between the cases, completing the arguments before lunch. The arguments are being webcast live this morning and will be available in the court's archives on its website later. We're ready to hear argument in 21-1035.
May it please the court, Mr. Alexander will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, this court should reverse the judgment of the Court of Appeals and remand this case to the Railroad Commission for two reasons. First, because the manner in which EOG located its horizontal wells in the pool at issue had the result of stranding the school fund's riverbed minerals. Thus, in order to prevent waste within the definition of that term under the Mineral Interest Pooling Act, once the voluntary offer was rejected, as a matter of law, Ammonite, the lessee of the school fund, was entitled to forced pooling. The second reason is that unlike what the Court of Appeals said, the Railroad Commission did not find as a matter of fact, did not conclude as a matter of law, that the monetary offer that was made by Ammonite was unreasonably low. And for that reason, that was not a basis for the commission's decision. And even if it were, it would have been wrong as a matter of law. Now, I think everybody agrees that the first issue is really the determinative issue in this case. So I'll focus my argument on that issue, but I'm prepared to answer questions on the other.
On the first issue, your statement of the issue presumes that a horizontally drilled well is part of a common pool with your client's mineral rights. But why are they part of a common pool when you're talking about horizontal drilling and fracking? Because that's very limited in terms of its reach, and it doesn't reach underneath the riverbed.
Yes, but and this was undisputed, there was testimony from Tim Smith that the hydrocarbon formation in this field, and let me give you the definition.
But if you define the hydrocarbon formation as the pool, even though there's no drainage from a common pool, you're going to require adjacent landowners who decide to frack on their land to undertake to frack on their adjoining neighbor's land. It's forced fracking, it's not forced pooling. So I'm kind of trying to figure out what we do with that in the instance where one neighbor decides to drill a well and it's not draining his neighbor's land because there's no common pool with horizontal fracturing, and then the adjacent neighbor says, well, I get to participate in your interests there on your land, or you need to drill under my land. And neighbor may not want to drill under the land because, as in this case, it's under a riverbed, so it's part of a watershed. So I'm having trouble mapping the Mineral Interest Pooling Act onto this situation, which involves fracking.
Well, I mean, and this is a great question because, all of the jurisprudence we have comes from the last century when all we had was vertical drills. Now we have horizontal, so this is the case that allows you to update that jurisprudence. Let's take a look at tab
But
2.
you're saying that, you concede that the well that's being drilled is not draining your client's interests. It's not reaching your client, it's not draining the formation under your clients. So what you seem to be suggesting is you're required to frack under our client's land, or if you don't frack, you have to pay out of your mineral interests.
Well,
How does that work in a case where you've got adjacent landowners who don't agree about whether fracking should take place?
let's look at the definition of waste. So let's go there. So this is under tab 1. So the term waste includes physical waste or loss resulting from locating wells in a manner that reduces or tends to reduce the total ultimate recovery of oil or gas from a pool.
From any pool.
From any pool.
Right, and so if you define the pool as the whole hydrocarbon formation, that could go on for miles.
It
But if
does.
you define the pool as the area that's being drained, which is what has historically been pooling, that's very different, right? Because you're not draining from your neighbor's pool. And the idea behind forced pooling was you drill a well too close to your neighbor's land, and then your next door neighbor says, "Oh, you're taking my oil and gas. I've got to drill an offset well, and that's really economically inefficient and bad for the environment." So we have forced pooling because we don't want all these close together offset wells to prevent a neighbor from draining a neighbor's land. And so from any pool in the definition becomes very important, because if you define it as the formation, you could be forced to frack your neighbor's land more than a mile away.
Okay, so let's break that down.
Okay.
So what you just described, the drainage, is dealing with correlative rights, where we have plenty of jurisprudence based upon vertical drilling. What I'm talking about is waste, which is different from drainage. And I think that the case that you can look at for that proposition is the Gulf Land case, decision by this court that made clear that drainage is different from waste. But let's get back to pool. What is a pool? It's a defined term under the MIPA. Section 11.041A defines it as, in addition to land and minerals granted to the, I'm sorry, wrong one, 85.001A. Pool means an underground reservoir containing a connected accumulation of crude, petroleum, oil, or natural gas, or both. So when you say that a pool can extend for miles, they do extend for miles. The Eagle Ford Shale has literally miles of pooling under the definition of the statute. In our case, when you talk about draining, somebody had been forced to frack miles away, that's really not the way what we're dealing with here. What we're dealing with here, let's look at the map. This is tab 2. What you have here is a situation in which there are horizontal wells that have been drilled by EOG on both sides of the river, okay? And the effect of that is to, going back to the definition, if those minerals are not produced, that tends to reduce the total amount of recovery. The school fund is being denied its share of recovery from the pool as a matter of law.
But it says total amount of, total ultimate recovery. Total ultimate recovery, not
Correct.
total recovery.
So the ultimate recovery, if you consider the area in which EOG has its horizontal wells, is in the pool. These wells are in the pool. These wells are in the pool. The riverbed minerals owned by the school fund are within the pool. If those are not produced, that reduces the ultimate recovery of oil and gas from the pool.
What does ultimate mean?
at the end of the day, I mean,
Does it mean at the end of time, or does it mean at the end of these wells? What, ultimate, I think of ultimate and much longer
okay, well, I mean,
timeframes, but
in
maybe
this
not.
case, it would be forever. I mean,
Why? Why is
well,
that?
Well, because given the fact that this is a meandering river, it is not economically feasible for the school fund to thread the needle to, I mean, we don't have
Under
that
existing
technology.
technology.
What's that?
Under existing
Well,
technology.
under existing technology, and yes, under existing technology, and under the testimony of Tim Smith, without EOG giving up 300 feet on either side of the river, which it never offered to do.
So when we're thinking about what will ultimately happen, is your position, and it may be the right one, that we're confined to current technology?
Well, I mean, I think yes, but even if you talked about, I mean, I would say yes. I mean, we are talking about, at the time that this offer is made, what can be done, and the notion that maybe in the future, technology could be developed that would thread this, and maybe in the future, EOG would give up 300 feet on either side, even though it never offered to do that. And maybe even though, and this is also the other thing, maybe that oil will increase to $10,000 a barrel, we'd be able to do it. So, I mean, at some point.
What alleviates the prospect of a double recovery?
I'm sorry?
So, what alleviates the prospect of a double recovery? Forced pooling where there is no drainage, which is what we're advocating for now, and later development of the minerals by another well that reaches the minerals. And then there would be drainage. So what happens?
Well, in that event, great question. In that event, if there's not a double recovery, because once you pool it, then everybody shares. EOG shares, and the school fund shares. School fund's share is less than 1%, but there's no double recovery. There's a recovery by the people in the pool. EOG teamed with Ammonite. So at that point, if you ultimately get recovery, huzzah, everybody gets paid. There's no double recovery by Ammonite. There's increased recovery by everybody,
Well,
which is what's
They
contemplated.
recover from the pool now.
I'm sorry?
Ammonite would recover from the pool now, but retain the minerals because they haven't been drained. And then later, at some different time, potentially, the technology evolves or the cost makes it worth it. The pricing makes it worth it to figure out how to drain under a watershed, and then
The false
and
premise.
at that point, will Ammonite be forced to go back and say, oh, wait a minute, we participated in this other pool, 15 years ago. Those people are now participants in our pool today.
No, I mean, the false premise of your question is that somehow you'd have forced pooling now, Ammonite gets to participate in the production. And mind you, and this is key, the EOG has the right, once there's pooling, to access those minerals itself, which requires no developments in technology. That technology exists, okay? But the false premise
But
is
are
that.
there reasons why a driller, an operating company, might not want to frack on underneath land it does not own? In particular, the Frio River, a watershed.
Okay, let me break that down. Is there a reason? Yes, there's a reason why it may not want to pool. And if you look at tab 4, which is the rejection letter, it explains why. And that's because it had, EOG explained, we have no voluntary pooling provisions in our leases. In other words, they have leases with people that say you may not participate in voluntary pooling. Okay, that's a contractual barrier. It's not a statutory barrier, and the statute trumps. So under the Mineral Interest Pooling Act, the mere fact that you have a contractual prohibition doesn't mean that you're not subject to forced pooling. That's not an exception. There's no contractual exception. And back to your question, Justice Bland, because it's a great one, once they've been pooled, it's not as if they are now Ammonite's minerals. They are now part of a pool. Everybody shares. They're EOG's minerals, 99% of them. And
So if
1%, yes.
So if Ammonite drilled under the river later, it would still be part of the pool, and
It would still
EOG
be
would
part of
share
the
in
pool.
that.
I mean, if, once you have forced pooling, whether it's Ammonite that drills or EO drill, it's part of the pool. I mean, once it's pooled, it's pooled. I mean, what they're trying to argue is, oh, well, you don't get forced pooling because you can just go drill them yourself. No, cannot. If you look at the testimony of their expert, which is in the first volume of the supplemental clerk's record, pages 398 to 399, he explains why that can't be done. We cannot snake beneath the river at this point. And so what you end up with is a situation, I'm back to waste, with horizontal pooling. If you strand those minerals, like the Chinese nail house that we put in our briefs, those minerals are wasted by definition, and under tab 3, if you look at tab 3, in that circumstance, the Railroad Commission shall order forced pooling. There's no discretion.
So your rule would be if you're only forced to pool and thus frack under your neighbor's land if the oil and gas is stranded. It would be limited to stranded oil and gas reserves?
Yes.
And stranded as of the time the Railroad Commission made its decision? Because I'm trying to see
Yes.
how your rule would work just for adjacent landowners anywhere in Texas.
I think it's a great question because,
And the concern I have is that a neighbor can say to his neighbor, well, you're fracking, I want your horizontal string to come over to my land. And if you don't agree, then, I'm gonna go to the Railroad Commission and achieve forced pooling, even though you're not draining my land.
That's a legitimate concern. Okay, and they could not get forced pooling because their minerals are not stranded. There could be some other operator that comes along that says, I want to access your minerals. Do you see in that situation? But in a situation where, like this one, where all the land has been tied up on both sides of the river, the ability of the GLO to get to get at those minerals is extinguished, and under the definition of waste, absolutely that constitutes waste because it reduces the ultimate recovery from the pool. Everybody agrees that the pool here, and this is critical, is the entire hydrocarbon formation. But back to your point, the concern about the adjacent landowner, no, your adjacent landowner could not get forced pooling, could not, because their minerals are not stranded. So yes, back to your question, is my argument restricted to stranded minerals? Yes, yes.
On the first part of 102.011, for purposes of determining what the relevant field is, it talks about a common reservoir for which the commission has established the size and shape of proration units, whether by temporary or permanent field rules. Has the commission done that?
Yes, I mean, well, you have to look at another statute. The size here, and this is one of the reasons you may recall that one of the proposed units was even nixed by the examiners in the proposal for a decision because it was too large. By statute, the size of these units are limited to 176 acres.
But has the commission established them?
Yes.
And so don't we have to give credit to that in terms of it being the commission's determination that there is a common reservoir of oil and gas?
Well, there's no dispute that there's a common reservoir. There is no dispute.
Well, it sounds like there may be, so there have been some questions about whether that's true this morning.
Okay,
So I'm
but
wondering if
I'm
we
talking
have-
about under the facts of this case, there's no dispute. If you look at the testimony of Tim Smith, he acknowledges that all of these minerals, it's not as if, and he says that, if you do a word search for the word barrier in volume 1 of the supplemental clerk's record, and what you'll see is he says, they come right up to the river, these wells and stop, but there's no barrier to prevent them going further. They're all part of the same hydrocarbon formation. Back to your question about, well, what about the concern about the watershed? That didn't even come up because they're so deep, that's not an issue. I mean, that is literally a red herring. So there's red lights on.
You finish your thought.
I'll wait for a rebuttal.
All right. Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Weber and Ms. Thompson will present argument for the respondents. Ms. Weber will open with the first 10 minutes.
May it please the court. To the question about what is a pool, what is a reservoir, I just want to clarify things. The MIPA as a threshold matter can apply only to a reservoir that was established by the commission after a certain date. And that's in 102.003 of the statute. And reservoir is the big miles away, and there's not any dispute that the reservoir, the Eagleford Shale area that we're talking about, there's no dispute that that is set. And Justice Busby, there's no dispute that the commission has established the requisite proration unit size for that reservoir. So when you're talking about a reservoir for purposes of the threshold applicability of the statute, there's not a dispute about that. What there is a dispute about, Justice Bland, is whether or not the creation of this forced pool, of this pooled unit that Ammonite asked the commission to give it, whether or not there would be production from whether Ammonite's tract, riverbed tract, would contribute to the production from that pool, and that it is undisputed that the answer to that is no. And I think that...
So your friend said the definition includes connected accumulation, and so is this a connected accumulation into the pool? And so because it's in a connected accumulation that...
I don't even know what he meant by that. But let me tell you what I think, how this all fits in. Is there the two most important concepts in the application of the MIPA to this case are waste and fairness, because the statute uses those two terms, and the way those two terms are used in the statute make this an easy case. Let's talk about waste for a second. Justice Young, the question of waste is the ultimate recovery. And yes, it can be forever, if the technology one day will justify, if the cost of oil and gas in the future will justify. But that's not just the only question. Yes, you can have waste if things are stranded. But that's not the standard under the MIPA, because the question is, will this forced pooling prevent that waste? And the answer is no, because the pooled unit that Ammonite asked for, the forced pooling that Ammonite asked for, would not prevent those minerals being stranded. And what's an important concept about waste...
I think that the argument is that it would prevent them from being stranded, because your client, for economic or contractual or other reasons, has decided to discontinue fracking at a point certain on, that go to the extent to the limit of their leased rights, of their oil and gas rights, and not go beyond that. And if the interests were pooled, then they'd have an incentive to explore for oil and gas and obtain production beyond their leased rights by fracking over into the remainder of what would be pooled under MIPA.
But that's not possible, and here's why. This court recognized in the Murphy versus Adams case how horizontal wells work, and how the production in these kind of unconventional formations, shale formations, work. You have long laterals. There's a heel and a toe. You have long laterals, and then along the lengths of the laterals, there are the perforations through which there's fracking, and there can only be production into the lateral through those perforations along the length of it. There's a heel and a toe. And then there's a back from it, the front end where you kick out, and then the back end where it ends. Those are completed there. And There's a take point.
Right. I understand the physical of a single well, but I think they say in their briefing that it would incentivize the rework of existing wells or perhaps the drilling of additional ones.
Well, that's not true. And we know that from,
Was there any disputed testimony on whether the wells could be lengthened?
no, there was not, Your Honor, because they can't. Because 30 feet these are thousands of feet long, and the riverbed is only 30 feet. Now, mind you also, the Railroad Commission has mandatory spacing, setback spacing. So we can't extend the well bore past the riverbed tract onto the other side.
And by the same token, they couldn't drill because of the spacing, right? Even if the technology issues, they'd also have spacing issues, or no?
Well, Your Honor, the question before this court is whether the Railroad Commission erred and abused its discretion in denying the specific MIPA force pooling that Ammonite requested for these specific wells. Because what we're talking about here is statutory interpretation.
So why would it not prevent waste?
Because those hydrocarbons will still be in the ground even if the Railroad Commission had granted the precise force pooling order that Ammonite requested. Those hydrocarbons are still there.
Stranding is never waste, is that your position?
I'm sorry, I didn't hear you.
Stranding oil and gas to where it can't be accessed either because of spacing issues or because of technology, that's never waste.
Stranding can be waste, absolutely.
Okay.
Stranding can be waste, but that's not the question for this court. The question for this court is whether the MIPA force pooling order would prevent that waste. And here's a super important concept.
You concede there is waste occurring.
I do not concede that there is waste occurring, although there certainly could be. I'm not going to.
I mean, if there are minerals under the riverbed that are not being captured, their argument is that constitutes waste. And it sounds like you're saying, yes, that's waste, but forcing pooling is not going to prevent that waste under these facts.
Under these facts, force pooling would not prevent that waste. If there is waste.
What should they have done? What should they have put in there? I mean, I understand your issue about the bonus amount, but aside from that, what should they have requested in order for their request to prevent waste?
The only way, well, I have a couple of responses. First, EOG could not have accepted any offer from Ammonite to voluntarily pool because it is prohibited by its leases. We could not have accepted, no matter what they put in there. If they'd have put 100% risk penalty, if they'd have said, no matter what the terms were, EOG could not have accepted that forced pooling. And Mr. Alexander just said, because our leases did not, they prohibited voluntary pooling. We couldn't have done it.
It's not voluntary.
Well, no, the offer first is the voluntary pooling.
So, right, but is there something in the MIPA that says it won't prevent waste if our leases don't allow us to accept it? It seems like that's an easy way to defeat forced pooling.
No, Your Honor, I'm addressing the separate question of, because you said, what could Ammonite have offered to prevent waste? And I was just saying, well, as a threshold matter, there's nothing we could have done to accept.
Okay.
So the whole thing about why didn't EOG accept the offer? Oh, you just should have accepted the offer. We couldn't. We could not have accepted the offer because our leases did not.
The rationale that was offered, I thought, was just that it didn't drain.
Your Honor,
nothing about
the tab number 4 of the Mr. Alexander's oral argument exhibits is the rejection letter that was signed by my law partner, Doug DeShiel, who's here, who tried the case in the Railroad Commission, and it goes through each and every different reason, lots and lots of reasons, including the question of the permissibility of that the leases don't allow.
So we're talking about a lot of rather complicated engineering concepts and, formations and lateral drilling and all these things. And, sometimes that's what we have to do in oil and gas cases. Here we have, though, a separate panel of statewide elected officials whose job is, in particular, to oversee this kind of thing. We have a statute that says if they find that it wasn't fair and reasonable, then that's it. And I just wonder whether I'm wondering about the standard of review and the extent to which we might be hesitant to second guess the the thinking about all of these technical concepts that has gone on at an administrative body that's tasked with doing this, and that has its own, is answerable to, you know, the public through the political process in its own way.
Your Honor, I hate to do this. I'm going to duck that question because I'm going to leave it to my colleague, Ms. Thompson, who's here representing the Railroad Commission, and I think she can speak best to that. From our perspective, this is the statute that the railroad, it's a technical statute, it's a technical thing, matter, and this is something that is within the wheelhouse, specific wheelhouse of the commission, and we think they're entitled to some deference. But I want to make 2 quick points. Fairness, fair share. The statute again and again and again says that the Railroad Commission can only issue an MIP order if it gives everyone a fair share. What's a fair share of production from a pooled unit if you contribute 0?
But what about the fact that you have apparently put wells just to the point where there cannot be anything else causing the stranding? So does that not sort of shift the fair, if we're going to talk about equitable principles, I'm not sure that doesn't cut the other way.
Well, Your Honor, we put them to where we could. We put them as far as we could under the contractual and regulatory parameters under which we operate. We only had leases to allow us to drill to the boundary of our lease, and the Railroad Commission has setback requirements under Rule 37, and the Commission also has specific field rules and regarding the between well, we can only be 300, it's optimal to put 300 feet apart. We drilled within the parameters. But what the MIPA says, the statute, the words of the statute say that the Commission's order has to guarantee a fair share. And if surface acreage allocation doesn't give everybody a fair share, then you can have some other manner of allocation. But the non-consenting folks, EOG and its lessors, can never get less than what they would get on a surface acreage allocation. So
would those setback requirements fully apply if there was pooling?
Well, it would be set, it would just, yes, except that it would be 30 feet further down the boundary. See, these are lease wells. These were not pooled units, other than the fact that Ammonite asked to get in. These were lease wells on individual leases. And so our boundary is the boundary of the lease. And what Ammonite, if there were a pooled unit, the boundary of the lease would be the other side of the Frio River, 30 feet. But we would still have to be back a Rule 37 number of feet from the boundary of the pooled unit. The tow could never extend into the Frio River and produce mineral from there. And that is undisputed. And this case this court in the Carson case said that an offer to pool that would dilute the existing mineral owner's interests without adding any production is, as a matter of law, is not fair and reasonable. And that is what Ammonite has asked this court to do. That is what the commission said, no thank you. And we urge the court to affirm.
Any other questions? Thank you, Ms. Weber. Ms. Thompson, we'll hear from you.
Thank you, Mr. Chief Justice. May it please the court, the Railroad Commission's decision is supported by substantial evidence on 2 independent bases: the lack of a fair and reasonable offer, and because the order that Ammonite requested will not prevent pooling. Going to Justice Blacklock's question.
Will not prevent pooling?
I'm sorry, prevent waste. I misspoke. Going to Justice Blacklock's question. There's no dispute here that the statute is unambiguous, but the Railroad Commission is tasked with applying the statute's general standards, in particular, whether the order is necessary to prevent waste.
I think Mr. Alexander's point is that the Railroad Commission labored under the misapprehension of the definition of waste to require drainage. And if the statute does not require drainage, is that enough? And the Railroad Commission ruled that MIPA requires evidence of drainage to apply. is that enough to send the case back? Because the Railroad Commission concluded that the statute requires drainage, and when in reality the statute does not.
No, it's not. The commission did not rely on misapprehension of the statute.
But if we were to conclude it had, then wouldn't we send it back for it to redo its fact findings under the correct standard?
Yes, as a general matter, if the agency misapplies the statute, then yes, remand is appropriate. That did not happen here. The contention is that the Railroad Commission, after years and years of regulating this industry, just missed that stranding minerals can constitute waste. That's not supported on this record. The Railroad Commission understands that stranded minerals can constitute waste. The problem is that the Railroad Commission does not have roving authority to go around the state and order people to produce minerals. So when we came to this hearing, we had wells that were already drilling and already producing. And those wells were not going to recover the minerals underneath the riverbed. So as EOG has already pointed out, the order that Ammonite asked for would not prevent waste.
What if there had not been wells producing?
We would have a different case. If the wells were not already drilled and producing, then perhaps it would be a different circumstance, and perhaps Ammonite would have been able to show at the hearing that this sort of reworking, extending the lines could have reached underneath the river.
But when you get one of these offers, just drill a well as fast as you can and then you're out of luck?
Your Honor, the MIPA reflects the very limited authority that the legislature has given in the Railroad Commission. The requirement of a fair and reasonable offer is because the free market controls oil and gas production in Texas. And this court explained in Carson, this fair and reasonable offer requirement contemplates a bona fide attempt to reach a contractual agreement. We did not have that here, the Railroad Commission concluded, because Ammonite demanded pooling even though the wells were not going to produce its minerals. Now, if at that time Ammonite had come forward with a plan, here's a proposal where you could extend your wells and we could request a Rule 37 exemption and there's a way that we could make this work, then we'd have a different case. EOG very well may have agreed to it voluntarily. We don't know because that didn't happen here. Instead, at the offer stage, Ammonite rested on the contention that it could demand pooling even though its minerals were not going to be produced. And even at the hearing, many, many months later, Ammonite did not argue to the Railroad Commission that these wells could be extended.
So the question that Justice Busby asked, I think kind of gets to the idea of if someone is in this situation and they very quickly complete a well or begin a well, will never be in a situation, and then they say, well, that well can't drain from the river. And if the commission is going to say, well, it's not producing from something, it's not going to change, you're not going to be able to actually produce from underneath the river. So even if it's waste, well, that's just too bad. That seems to create a pretty weird incentive structure given the whole point of the MIPA to avoid this waste.
Well, one purpose of the MIPA is to avoid waste, to be sure, but the Railroad Commission has not been given statutory authority to go around and generally try to incentivize production.
Yeah, but does it need to disincentivize it in the way that seems to have
Well, I
happened here?
don't think that happened here. If Ammonite, Ammonite controls its own application. So if the concern is timing, then applicants can move quickly.
So I want to make sure I'm understanding. It sounded like your colleague was not conceding that there's waste, but saying, yeah, there may well be, and that's too bad. That's also your point now. I think they didn't do a good enough job at the hearing. They didn't, do something time enough. So yes, there may well be waste. It satisfies Section 85.046 very well, but too bad.
We can assume for the sake of argument that there would be waste here, although Ammonite did not actually put on evidence as
all
to
the stuff in both briefs from you and from your colleague that talks about, well, it's still there, it's not going anywhere, it may be there, that we can set that aside. That really is not something you're relying on.
Well, Your Honor.
That's just drainage.
So we agree that stranded minerals can constitute waste. But the solution to that problem is not this MIPA order. The Railroad Commission has other authority given by the legislature that it can use to prevent waste. For instance, if Ammonite wants to drill a well, it can ask for a spacing exemption.
The statute says it uses the word tends to reduce the ultimate recovery, and I'm wondering if that isn't relevant to what we're talking about. The action that was taken, putting these wells just where they are, tends to reduce the ultimate recovery, because it may well be that, yeah, those minerals will be there. They'll be there until the Lord comes back. Well, that could be the case. Likewise, if the pooling order were to be granted, it would tend to avoid waste, because maybe you'll discover, well, okay, actually we can extend, or maybe we get some permission to extend, and people would say, all right, fine, if that's the way that it's going to be, we're not going to, for all the rest of the river systems of Texas, develop well plans so that we can get it just close enough and make sure that the river is excluded. And too bad, well, I mean, you can't really blame us. They're not contributing anything to it, and extend that process. Why would that not be a reasonable solution, given the statutory language of tends to reduce, something that tends to have a particular result?
So, Your Honor, we could accept that, the tends to language is found in the definition of waste. So we could assume that stranding minerals meets that standard. But again, tends to is a standard at a very high level of generality, and the legislature has delegated authority to interpret and apply that standard to the Railroad Commission.
It seems like your argument's against the financial interest of the state of Texas. Can you explain that?
Well, Your Honor, to the extent you're talking about the GLO's minerals, of course, I'm not here to represent the GLO. I represent the Railroad Commission, and the Railroad Commission has to act within its statutory parameters. If the legislature...
But you said there were other things that the Railroad Commission could do to allow the recovery of those minerals. Would that include addressing the technical problems with drilling within this narrow strip under the river?
If Ammonite or another operator comes to the Railroad Commission with a plan for producing these minerals, the Railroad Commission will be happy to consider it.
So even if the well had to cross over lease lines, could the Railroad Commission allow that?
Potentially. But again, the commission's job is not to figure out how to get all the minerals in Texas out of the ground. The commission's job is to get out of the way so that the market can do it. So if a commission rule like the spacing requirements is preventing Ammonite from drilling, then they can come and ask the commission to get out of the way. Here...
Can I just ask I just want to be very clear on this. So you can accept for purposes of the argument that waste is occurring, that the stranding of these minerals under the riverbed constitutes waste, but the position is that forcing pooling would not prevent that waste because the currently existing well bores do not reach under the riverbed, to which the petitioners respond, well, but those well bores could be extended, or new wells could be drilled that would access those minerals. And your response to why that wouldn't prevent waste is what?
So there are three problems with these wells could be reworked scenario. The first is that it wasn't presented to the Railroad Commission. This court cannot reverse the Railroad Commission's decision based on a theory that was not presented at the Railroad Commission. The second problem is that, again, the statute looks to the time of the order for determining how to issue the appeal. I seem about to run out of time.
Well, can I hear the three real quick? So the
Yes.
second one is you look to the time of the order, and what do you see there?
Absolutely. And the MIPA doesn't give the Railroad Commission authority to order EOG to rework its wells or to drill any new wells. All it authorizes the Railroad Commission to do is enter a pooling order.
But if you pool, then the market could decide if it's worth it to them to extend the wells, right?
Yes, and the market could already do that. That's why the MIPA requires a...
Sorry, they didn't argue it. There's no authority to force them to do it, and the third one?
The third problem is that there's just no evidence in this record that it's actually possible. Okay. EOG says it's not possible, but the point is that the record doesn't support it.
Thank you.
There's a thought that the operator here, or the lessee, caused the stranding by stopping horizontal drilling short of the riverbed, but did the operator have any right to drill under the riverbed?
No, Your Honor. At the time that EOG took out these permits, it didn't have that authority. Now, the court certainly could have a completely different case in front of it in which someone who has a mineral lease under a riverbed has negotiated in good faith and made a bona fide attempt to get these together. If there were a problem of producers or operators holding out and just out of spite refusing to develop under the riverbed, I think that would be something that could be dealt with, but that is not this
But you
case.
said if they've already drilled the wells, they're out of luck.
Under these circumstances, yes. There is a
So
jurisdictional.
how would you deal with the holding out situation?
Well, the problem here is that there was not a good faith, fair and reasonable offer to pool these voluntarily. Once we get to a situation where there's actually been a bona fide attempt to reach an agreement, if there's some problem, then maybe we'd have a different case.
So the statute says at 102.013B says the commission shall dismiss the application if it finds that a fair and reasonable offer to pool voluntarily has not been made by the applicant. Is there any dispute here that they did so find?
No, that was absolutely found by the Railroad Commission.
And so the rationale that the Court of Appeals used hasn't gotten much airtime today. And I'm wondering if we conclude that the idea that the 10% risk penalty plus, if something else were to come, if we say, well, that as a matter of law cannot be the basis for finding something to be unreasonable and unfair, is the proper result to send it to the Court of Appeals to consider the remaining issues? Or because you've defended the Commission's result a lot, but haven't really defended the Court of Appeals much.
Yeah, absolutely. So it could be appropriate to remand. I don't think that is supported by principles of judicial
Do
economy.
you want to
but-
defend the Court of Appeals on that ground at all, or?
Well, certainly, the commission agrees that aspect of the offer is part of what made it not fair and not reasonable.
The 10% plus all the way up to 100 if necessary?
Well, Your Honor,
I find it puzzling.
10% is the bare minimum. And Ammonite's evidence at the hearing was, well, I just offered the bare minimum because Professor Smith's treatise says you should offer at least 10%.
I thought they
We
also.
were at 50% though, because isn't that what the examiners ordered and they said, yes, we're fine with that?
Yes, and that's what the Court of Appeals rested its decision on, that even Ammonite agreed that a five-fold increase would be fair and reasonable. The 10%
But if you
was just
evaluated
not
at the
enough.
time of the order, then don't you consider it to be 50%?
Well, Your Honor, we're talking about, when it comes to the fair and reasonable offer requirement, we're talking about the time of the offer. That's what this court explained in Carson. Now, once we're talking about the actual pooling order, we're talking about the time of the hearing.
So there was
or
no
the time
reason,
of
the
order.
examiners were just, that there's no reason that they should have even considered whether it should be raised, because if you offer it at 10%, you're out of luck and it can never be raised.
That's not necessarily the case in every circumstance. Maybe there could be an evidentiary showing that
I thought it
because,
was jurisdictional.
Your Honor, a fair and reasonable offer is jurisdictional.
Right.
We're not saying that the statute requires any particular terms in that offer. The fair and reasonable offer contemplates market conditions. Because again, it's technology and economics that drives oil and gas in Texas. Oil and gas development is not supposed to be directed by the Railroad Commission. So if Ammonite or another leaseholder wants to come up with a plan for extending wells under the riverbed and do it in a bona fide attempt to reach a contractual agreement, the Railroad Commission's not standing in the way of that. That's what the legislature has required them to do before they can even invoke the Railroad Commission's authority.
We've been assuming here that there very well could be waste. I want to make sure I understand your position. Are you arguing that there is substantial evidence that these minerals will not be stranded, are not stranded? Or are you not making that argument?
No, Your Honor. Ammonite didn't put in any technical evidence at all. So we've just assumed for the sake of argument that there are stranded minerals here, but there actually was evidence at the
Are
hearing.
you relying on Tim Smith's evidence that, that these minerals would not be wasted absent forced pulling?
The Railroad Commission's order did not enter a finding of fact on that, and the substantial evidence standard looks to the finding of facts entered by the Railroad Commission. But that's certainly part of the evidence that the commission considered when determining whether this would be an ultimate loss of minerals. And it's not, because the minerals will remain in the ground. So even if there is waste, the order that Ammonite asked for will not prevent it. See, I'm out of
Any other
time,
questions? Thank you, Ms. Thompson. Mr. Alexander, you have 5 minutes.
What is your response to her argument that reworking the wells just isn't going to work for her 3 reasons?
Several things. First off, it can work because it is harder to extend a well once it's been completed.
And what about the argument that this just wasn't presented to the Railroad Commission?
I'm not sure I understood that argument, so help me a little bit more with that.
Is there any evidence in this record that it can work? Is there any evidence before the Railroad Commission during the administrative proceeding, in that administrative record, that these well bores can be extended or re-drilled in order to access?
Well, let me break that down. First off, and I think this gets back to the timing question, can I address timing and address that as part of your question as part of that? You have to remember, the case you need to look at is Carson. The time that we focus on is not the time of the hearing. We have to remember in Texas, it's very unique. This is a state that encourages voluntary pooling, and the time that you focus on under this court's decision in Carson is the time at which the offer is made. Let me just read this from the Carson decision. We do agree that the offer must be one which takes into consideration those relevant facts existing at the time of the offer, which would be considered important by a reasonable person in entering into a voluntary agreement concerning oil and gas properties.
So if we review this administrative record, will we see that Ammonite argued to the commission that at the time of the offer, these wellbores could be extended or re-drilled in order to access the minerals under the river?
Yeah, you will find that if you look at the testimony of Tim Smith at 398 to 399, and if you do a word search for the word barrier. In other words, everybody agreed that, you know, these horizontal wells, many of which traveled over a mile and just stopped hundreds of feet away, there was nothing to prevent them from continuing.
You say there's nothing to prevent them, but has there ever been a case where a lessee that has no lease rights drills and invades an adjoining landowner's land to capture the oil and gas? I mean, ordinarily, with voluntary pooling, you're requiring a well to be drilled, the lessee to drill the well where the lessee has the lease rights. But in this case, you're saying, well, we would require the lessee to trespass on the adjoining landowner's land to capture that oil and gas, and doesn't have the right to do that.
It would have the right if it had accepted the voluntary offer. In other words, what Ammonite is saying.
Has there ever been a case where the voluntary pooling carries with it the right to actually drill wells and extend underneath the other side's land?
There's never been a case like this one. Let's make this clear. Okay, let's make this clear.
It's complicated.
Okay, it's complicated for this reason. So the statutes against preventing waste go back to 1919, but throughout the entire 20th century, all wells went this direction. It wasn't until the Barnett Shale exploded in the 2000s that we got horizontal drilling. So to answer your question, no. Is there any case we can point to that provides precedent for what we're asking for here? The answer is no. But if you adhere to the statutory definition of waste, there's no question, and they've conceded it, that if you strand minerals, that constitutes waste. And then if you look at the whole purpose of forced pooling, You're saying that the party, Ammonite, who's requesting for pooling, has to participate in the payment for any extension that occurs. Back to
Would
time.
the surface owner have to agree to an extension, or is that simply something that the Railroad Commission can command and the adjoining lessee could agree to because the adjoining lessee wants to obtain forced pooling? But if the surface owner and the lessee have different interests and the surface owner is not interested in having horizontal fracturing extending under the surface of their land, would that matter?
Well, I mean, in this case, the surface is a river. Okay, it's the riverbed minerals that are owned by the school fund. And there's no prohibition. Mind you, these wells are 1,000 feet deep. And so, no, the surface owner, the river owner, whoever that might be, I think it's the state of Texas, doesn't have to consent. There is requirement that for the GLO to consent to forced pooling,
I mean, is there
which
a
it's
cause
done.
of action for trespass when an operator extends or invades underneath a surface owner's land without the surface owner having granted rights to that operator? I'm just asking. I don't know
No,
the
it's a
answer.
great question, but in this case, that's just not an issue, because literally the only, and this is under, I mean, if you look at section 11.041A, that establishes that the riverbed minerals are owned by the permanent school fund, and it's only those riverbed minerals, so the surface here is literally a river. You don't have to get consent. There is no surface owner of that river other than the state of Texas. So that, I mean, that's not an issue here. I mean, getting back to the timing question, I want to make this clear. At the time the offer was made, 14 of the 15 wells had not yet been completed, okay? There was nothing to prevent them at that point from going just a little distance further to access the minerals. The only thing that occurred, and they conceded it, was that they had a contractual prohibition against doing that. But again, in this case, this goes back to the 1917 constitutional amendment, Article 16, Section 59A of the Texas Constitution, which puts natural resources a matter of public interest. So their contractual prohibitions have to give way to the superior power of the state to order forced pooling. And back to the question about deference to the commission that you had asked about. In this case, we're dealing with an unambiguous statute. This court has said in the Southwest Royalties versus Hager case, Brazos Electric Co. in recent years, that deferring to an agency's construction is appropriate only when the statutory language is ambiguous. Otherwise, agency deference has no place.
Along those same lines, I wonder whether there's a difference, perhaps, in the typical administrative law case, the government is prejudicing the interests of someone's current interests and allegedly prejudicing their rights. I mean, here, this is a little bit different in that you're coming to the government for help to force someone else into a relationship with you that they don't want to be in.
Correct.
Which is a little bit of an odd posture. And I wonder if that aspect of this has an impact on the extent to which we would afford deference to the commission under what is already a very deferential statutory regime.
And the answer is no, because what we're dealing with, and there's really two statutory provisions that I think are key. One is the definition of waste. I think we've all agreed now that if you strand, that is waste. The other is section 102.011, which talks about, and I think this goes back to timing, you can force pool where the owner has drilled or has proposed to drill. So you can have forced pooling even when there's an existing well. So all we're asking in this case is for effect to be given to unambiguous statutes. There's no agency deference owed in that situation at all. This court has made that clear. The facts in this case are undisputed. Everybody says there's no drainage. We agree. But there is stranding. And when there is stranding, that constitutes waste. And the legislature has said in that circumstance, mandated by the 1917 constitutional amendment, that forced pooling can be had when there has been a rejection of a voluntary pooling offer. I see my time has expired.
Any other questions? Thank you, Mr. Alexander. The case is submitted, and the court will take a brief recess.
All rise.